Welcome to Essential Estate Experts, the estate planning podcast and ultimate resource for understanding estate planning and elder care law, brought to you by Screenfire Media. Let's get started.
Hey there folks, Chuck here. Thanks so much for joining us for Essential Estate Experts, where we bust myths and break down the complexities of estate planning, wills, trusts, and the nuances and variances that occur from state to state. You know, all that stuff that we don't like to talk about or think about, but we need to. We're so glad you're here, and we look forward to opening this world up further to you. But before we get started, I need to make a quick note. We ask that you please be aware that the information provided on Essential Estate Experts is for entertainment and informational purposes only. Listening to this podcast does not establish an attorney-client relationship. Always consult with a qualified lawyer before making any decisions related to legal matters, and do not take legal advice from a podcast. We appreciate you listening, but that's not what we're here for. So if you're listening on your favorite podcast app, we love it. Thank you so much. Rate us 5 stars if you can. If you're watching us on YouTube, give us a like, subscribe, and if you find this episode useful, please share it with your friends, and check us out wherever you find great podcasts. All right. Well, I am so excited because today we welcome attorney Wendy Mara, who heads up Mara Law in Ormond Beach, Florida. Wendy's a recognized expert in family and domestic law, probate and wills, guardianship, and business matters, especially in the state of Florida, which is where most of our focus is going to be today. But don't worry, we're going to be talking about a lot of stuff that'll be relevant to you, even if you're not in Florida, so stick around. Wendy, thanks so much for joining us on the show today.
It's my pleasure. Thank you for inviting me.
Leading the conversation will be my colleague, Marc Zasada. He's the managing director here at Screenfire Media. Marc is a published author who has written extensively on matters regarding estate planning, and I can't wait to hear how this conversation goes. So, okay, Marc, let's talk.
Wendy, thanks again for joining us. Can you tell us just a little about yourself and your journey into estate planning and family law, an area which I have learned is never without drama?
That's for sure. So I like to say my first career is mom. I have 6 children and 3 grandchildren, so that's always kept me pretty busy.
Wow, and yet
I
you're a lawyer on the side.
am, yeah, really. And before I became an attorney, I was actually a high school teacher for 13 years. I was sort of like a late bloomer. I graduated from Stetson University at the age of 30, taught for 13 years, and while I was teaching, decided I wanted to do something different and actually went to University of Central Florida to earn a master's in business administration and took a business law class. I absolutely loved it and decided that I was going to go to law school. So I was actually in my mid-40s when I graduated from law school. So I had lots of life experiences, including a divorce that I had. So
Okay.
family law seemed to be a natural fit. I did do some business law when I first graduated from law school with my M.B.A. That seemed to make sense. But I wanted something that was maybe a little bit more personal than business law. So then I went into practice with my husband, who is no longer practicing, but we did work together for quite a while. And then I did a lot of family law, and then it sort of blossomed into, well, these people, after they got divorced, needed to have some estate planning. And then, oh, some of these people have children who have special needs, so let's do some special needs planning. And then I started to do a lot of pro bono work, and I was doing some pro bono work for one of our local agencies and started doing some guardianships. And now I'm practicing solely in the area of elder law. I hired another attorney to handle the family law, and this area of practice fits me very well.
Explain to us what elder law is exactly.
So, elder law is very broad, and it includes probate, guardianship, estate planning. We do a Medicaid long-term care planning. I am VA certified, although I don't usually do VA applications because attorneys can't get paid for that unless care denied. And I do lots of special needs planning, which has become near and dear to my heart because I now have a grandson with Down syndrome. So that's
Oh my.
something that I'll be using personally in my family.
Now you're practicing in Florida, a state with lots of elders. And one thing I've learned in this work is that things can vary a lot state by state in terms of estate planning, probate, all those things. So what are some of the special issues that people encounter in Florida? Florida's a little actually famous for being different in many ways. Are there special quirks of Florida law that people should know about? A lot of people move to Florida as they age. What should I know about estate planning in particular? What mistakes people make in the state?
So you want to make sure if you have an existing will, and let's say you don't really want to change who the beneficiaries are and who's the personal representative, still have an attorney review it. Florida does accept into probate wills from other states. However, they have to follow the laws of that particular state. So if they're legal in that particular state, they're legal in our state, with the exception that we don't accept oral wills, which some states do, and we don't accept handwritten wills. So those are a couple of caveats. Also, in Florida, most attorneys are going to prepare what's called a self proving will. And that's where the testator or testatrix, if it's a woman, is signing the will. There are two witnesses, and there's a notary there, and everybody signs. And then there's an attestation at the end, basically in layman's terms saying, yeah, we all sat here together and we signed together and we saw each other signing and we were witnesses to it. And when you do that, you have a self proving will. You never need to go back and look for witnesses. We have probated quite a few wills from other states that were not self proven, and we had to go back and try to find witnesses. And sometimes there are people who've signed wills that didn't even know who the witnesses were. It was somebody, they went to a bank and there were a couple people there at the bank and they had them sign as witnesses. Or if those people are no longer living, there's a lot of ways around that, but it's just a lot more work. And the safer route is to just do a new will. A will is not that expensive. If you have assets, I've had people who, I have one case where there was $2 million in assets and a hand done will. The people did it themselves. Now, first of all, with that amount, there were a lot of properties. With that type of estate, really that person should have had a trust. And all of those assets should have been in trust. It shouldn't have gone through probate. But it did go through probate and it was a mess. And so sometimes we have unintended consequences when somebody does something and they don't get the legal advice. Is this valid? Can I do this? So, for what it costs to do a will, it's not a whole lot. And many times the people are distributing homes and IRA accounts or 401ks. I mean, all of their assets. It's a lot of money. And sometimes it goes poorly. And we have one case where this woman refused to do any estate planning. And she just told her cousin, hey, you're going to get all of it. You're my only living relative. Well, come to find out, her father had been married before and she had all these step siblings that she was not aware of. And so the people who got her estate were people she never knew. And so she had just done the estate planning. That I could tell you lots of stories like that. But as far as things that are crucial in Florida, our homestead is a protected asset. And one thing that I've run across is people have instructions in their wills to sell the homestead.
Tell me, what is a homestead and what is a protected asset?
Sure. So a homestead is where you live, your home.
Okay.
And in Florida, our homestead protections are very broad. It not only includes a home or a mobile home, but if you live in an RV, if you live in a boat, and that you consider that your residence, you live there full time, that's your homestead.
Hmm.
And those are protected from creditors.
Ah,
So if you have medical bills, you have credit card bills, they can't go after your homestead. A creditor, like if you have a mortgage, then, and there's a lien on the property, that's different. They can either require payment from the beneficiaries or they'll foreclose. If you don't pay your property taxes, it's going to be foreclosed upon. Association dues or condo dues, it will be foreclosed upon. But for the most part, it's a protected asset. If you have language in your will to sell that homestead, it's no longer protected. And every creditor is knocking on the door wanting to get paid. So, a simple thing like that, you write your own will and say, hey, I'm going to have my personal representative sell the house. If you have a lot of creditors, and some people will say, well, I have no creditors. We don't know what's going to happen at the end of our lives. We don't know if we're going to have major medical bills, funeral expenses, hospice. There's all sorts of bills that you don't plan on and anticipate, but that could happen. So that's just one example. Many people have language in their wills that if somebody contests the will, they don't get anything. That's not enforceable in the state of Florida. You can still put it in there and maybe it will have somebody think twice before contesting, but it's not enforceable. But the biggest issue is we have many people who've been married previously and they want their children to benefit, to be beneficiaries. Maybe they married a second husband later in life, and that second husband has his own family. And so somebody will prepare a will, and it goes for a trust also, and leave everything to their children from their first marriage. Well, as a spouse, you are entitled to what's called an elective share, which is 30% of the value of your estate. And so your spouse or even your spouse's family, if your spouse lacks capacity and your spouse's family can file and contest and say the spouse is entitled to 30%.
Regardless of what it says in the will or the trust?
Exactly, exactly. And not only assets that are probated and assets that are in trust, but even counts like bank accounts that have pay on death,
Uh-huh.
or life insurance policies that have pay on death. All of that is considered when determining what that 30% is.
Ah, wow.
And then the homestead, the same thing. Let's say this older lady gets married and she has her home and the spouse has his home, but they reside in her home. That's their homestead. He's now entitled to something. If she passes away and that home was just in her name, he's entitled to a life estate, even if her will says her children get that house. The spouse is entitled to a life estate in that home. If there are no children involved, can stay there for the rest of his life.
Wow. Wait, so
Yeah.
let's get this clear. So Mabel gets divorced. She has children from a previous marriage. She remarries George. There's no new children. Maybe they marry quite late in life. And happens probably a lot in Florida. People move there, they retire, right? They marry at 70.
Mhm.
And they're married for just a couple years, but they reside in Mabel's house that she owns. Mabel has written a will in which she gives the house to her children from the previous marriage. And maybe George isn't even mentioned in the will. I could see that happening, certainly if people marry later in life, right? You're nodding your head. I'm constructing a circumstance here, but you're validating
No,
it. So Mabel dies, and it goes to probate, to court, and all the children from the previous marriage show up, and the house is worth a few $1 million. And the judge says, what? Says, sorry, George gets to live in this house for the rest of his life because it's his homestead?
yes. So it depends on the family situation. So there's a lot of variables with that.
Sure.
But one thing you said that the first thing, and there's a lot of issues that come up with that whole scenario.
Okay.
And I've had one. So let me share one that I've actually had. Of course, I'm not going to share names.
Good.
So, husband and wife never divorced, but didn't live together. They had been estranged from each other for probably 10 years. Florida does not have legal separation, by the way. So that, sort of adds to the story.
Huh.
And husband dies. He had a will. And in his will, the will was created before he even got married. And in the will, everything was left to his sister. Sister was personal representative. Everything's left to the sister. The wife comes to see us. Well, because the will was written prior to them even getting married, the wife is called the pretermitted spouse. It's a legal term. So basically, the court's going to say, well, this will doesn't count because he wrote this will before they even got married. And so he probably wanted to include his wife, but just never updated his estate planning. So we're just going to say that this will doesn't even exist. And we're going to distribute the assets based on intestate succession. There were no children. All there was the sister who thought she was going to get everything, right? There were no children. Therefore, the wife is entitled to everything. Everything.
Wow.
Yeah. And that was obviously not the intent.
So, for listeners who may not be familiar with these terms, intestate succession, explain that very briefly.
Mhm. So if you have a will, the will is probated and it's a testate administration. If there is no will or the will is deemed invalid, then it goes by intestate succession, which is in the Florida statutes. And every state has a similar provision. And so basically in Florida, if you don't have a will, if you are married, then your spouse is the beneficiary. Unless if you have a homestead, your wife gets 50% and your minor children get 50%. So you can imagine that scenario.
Right, right. Yeah, minor children, your minor children get 50%.
Minor children,
Okay.
yes. And then the rest of your assets, your spouse would get 100% of those. If there is no spouse, and let's say there are no children, then if there were children, descendants, then it's no spouse, the children would take equally. So if there's 4 children, they're all living, they all take equally 25% of your estate. If one of your children predeceased you, then that share goes to grandchildren, if there were grandchildren from that particular deceased child.
I'm gonna stop you there because it's gonna get really complicated.
It is.
I know that in intestate succession, there's all these rules depending on children, grandchildren. But the bottom line is, if you die without a will, there's a set of laws that says who gets what, and it may really be not what you want.
Exactly.
You may think your children from a previous marriage or something are going to get taken care of, but you really don't know what's going to happen unless you study all these laws and you have a lawyer, and at that point get your will and possibly your trust in place. The other thing I'm hearing here is judges seem to have a lot of power in this. You told me the judge could invalidate the previous will because, hey, this fellow never updated his will when he got remarried. So obviously, we'll just throw this will out the door. Now, that may not be what this man wanted. He may have thought that previous will was still valid and that his new wife, maybe she's independently wealthy, maybe she didn't need any of it. But the judge decided. That's what I'm hearing.
So, not exactly.
Okay.
The judge has to follow the statutes and case law.
Right.
So the judge doesn't just arbitrarily say, I don't want this person to take. And the judge has to follow what the law says. So sometimes the judges are having to enforce things that they don't necessarily agree with and they don't like, but that's the law. That's what we have to do. And so it's sometimes heartbreaking when you see results that was not the intent of the person. I had one where somebody had a will and they had wanted to make revisions to that will and actually cut out some stepchildren who apparently after the death of their father wasn't very nice to the stepmother. So she wanted to cut them out, leave everything to her siblings. So she hand wrote on her will and she initialed it and signed it and did everything she thought. It's not valid. You have to create a new will with all of the requirements of a new will. You can't just write on your existing will that you want certain changes and think that's going to save the day.
That's a huge thing that people probably don't know. Right, I bet people hand update their wills all the time as things change. They don't wanna go back and pay a lawyer
Exactly.
$500 or whatever it's gonna cost to update it. So I'll just write a note here and sign an initial, and everything will be fine." And when it's over, they're gone. They don't know that everything's
Right.
screwed up,
Right.
right?
Well, and I also get parents are famous for that. Well, I'm going to give everything to my oldest child, and he will honor my wishes and split that up amongst all of the other children.
Oh my god.
And there are some people who honor that, but there are lots of people who don't. Or let's say that older child had creditors. I mean, it may not be even up to him, or maybe the older child becomes incapacitated. So you need to talk to an attorney before you do anything. And another thing that people tend to do is they have a disabled relative, a loved one, somebody that they really want to help. And so they say, well, I'm going to give a really big amount to this particular person because this person can't work and really needs the money. Well, as soon as that person inherits that sum of money, that person loses Social Security benefits, Medicaid, and especially the health care that comes with Medicaid.
Right.
So you need to talk to an attorney so that there's a special needs planning. There are trusts that can be created to protect that individual and make sure that individual gets the help that you want them to get, but doesn't in the meantime hurt them in other ways.
I've heard that before. You can think you're really helping somebody by leaving them a lot of money, but depending on their circumstances, you could really be screwing them up. You mentioned someone who's has special needs and is on public assistance, and you're screwing up their public assistance. What are some other ways that leaving someone money can be doing them more damage than good?
Well, if you have somebody who has substance abuse issues,
Yeah.
or somebody who has gambling issues, or somebody who just can't handle their money. No, I'm not saying you shouldn't give them anything, but it really should be in trust, and somebody else should be handling those funds and giving, and maybe instead of for an addict handing that person money, maybe pay rent and pay directly to the landlord and don't give it to the individual. So there are things that if you're wanting to help somebody who has those horrible addiction issues, there are ways to help those people without hurting them in the long run. Because if you just give an addict, a pot of money, that's going to be gone in no time, and we know what it's going to be gone on.
If I inherit money and then I get divorced, does that money become community property? How does that work?
So, Florida is not a community property state, first of all.
Okay.
Second of all, there are certain things that are considered non marital. One of them is an inheritance. So, if you inherit money from mom or dad, it is a non marital asset. Now, if you inherit $5 million and it's generating a lot of income, that income could be considered for alimony and child support purposes, but the asset itself is non marital. However, once you take that money and put it in a marital asset, so let's say you take that money and you purchase a home and you put it in the name of you and your spouse, it's now a marital asset. And the court's going to consider that that was a gift. And what we find is during the divorce, all of a sudden, every dime that was given was not a gift; it was a loan. And of course, the courts want proof of that. Okay, well, where's your promissory note? So if the intent is to not have that become a marital asset, then keep it in your name solely. Another uh, asset that is a non-marital asset is if you receive a settlement for personal injury, those funds are a non marital asset. They're intended to help you either for the pain and suffering that was caused due to this personal injury, or maybe you can't work now, or you need whatever health care. That's a non marital asset as long as you keep it separate. That's the important part. And then anything you bring into a marriage, premarital assets, are non marital assets. Again, you have to keep it separate. That's the important part. And it gets a little tricky, as we talked about, when you're talking about a homestead. If you're living in a home and it's a premarital asset, if you were to get divorced, the spouse could say, well, yes, it was a premarital asset, but you used income. The income that we earned while we were married was used to pay off the loan. Well, income's a marital asset. Unless you, then this is assuming you don't have a premarital agreement, but income is a
Yeah.
marital asset. If you've used your physical labor is a marital asset. So let's say you're handy and you fix up the home and it's improved the value of the home. That's a marital asset. And it's now that part that you've improved or money that you've spent, marital funds you've spent, those are all considered a marital asset, and your spouse is entitled to a portion of that.
Not a community property state, but there's this
Yeah.
thing called marital assets, which sounds a lot like community property. But anyway, bottom line, it's complicated and people screw up when they write their wills and they screw up when they inherit money right?
Yeah.
Because they don't know these fine points, and they don't talk to an attorney, and they just willy-nilly drop money into a joint banking account or whatever. They don't think through the consequences, and they don't know the consequences, and they don't realize that what is written on a piece of paper doesn't necessarily mean anything in a court of law, right?
If it's not executed properly and not following the laws of that particular state. Yeah, so it's really important to go ahead and get a consultation, even if you don't plan on actually doing anything right now. Get a consultation, find out what the laws are, and make sure that you're protected. And one of the advantages with our firm is we do not only the elder law, but we do the family law. So understanding the consequences of what could happen not only if you pass away, but if you divorce. That's a real advantage for us that we have. And also one thing that I noticed, we talk a lot about wills and trusts, and that's important because people have worked hard all their lives to accumulate certain assets. But when people come to see me, I tell them I'm primarily right now concerned about you as a person. Who's going to make healthcare decisions for you if you become incapacitated? Who's going to pay your bills if you become incapacitated? If you need a guardian, who's going to serve as a guardian? So, all of those, I call them advanced directives. So, power of attorney, healthcare surrogate, pre need guardian. Those are very, very important because if you don't handle those things, then somebody will have to get a guardianship if you become incapacitated. If there's not somebody who has the legal authority to make decisions on your behalf and to handle your assets on your behalf. So, a guardianship is thousands of dollars, tens of thousands of dollars. It's expensive.
Going through the court system to establish guardianship can cost tens of thousands of dollars
You
of
can.
unnecessary money. If the proper documents were in place in the estate plan, people wouldn't have to do that
Most of the time.
most of the time.
Yeah, most of the time. There's always that. It depends.
This is a
Right?
legal show, folks. When it you got to say most of the time, probably. You can never say absolutely X is going to happen if you do Y,
Yeah.
because
We
so
never want to pin
erase
ourselves
that.
down.
Yeah, we can't nail any of that down. Every circumstance is different. Go back to the beginning of the show with the disclaimer. Okay. So what I'm hearing is estate planning is crucial for when you're alive, not just when you're dead. Because imagine you're laying in a hospital room, you're unconscious, and your three children are staying there arguing about who's going to take control, pay your bills, take care of your house, take care of whatever needs to be done. You don't want them staying there arguing.
No. Let's say you don't have a spouse, you have a car accident. Your children have no legal ability to go into your bank accounts and pay your bills and get in touch with the health insurance company, or even if they wanted to and everybody was getting along. They don't have the legal ability to do that
Right.
without a power of attorney. So it's so important. And then, of course, choosing those people that for your power of attorney, you want to choose somebody who can handle money, can handle finances,
Yeah.
somebody that you trust. For your healthcare surrogate, many times the healthcare surrogate includes language for a living will, how you want to be treated at the end of your life. Most people say, I don't want to be hooked up to machines. Choose somebody that you know can make the tough decisions that you would want that person to make. And that's crucial. Some people, well, I will just have my oldest child because they're the oldest. Well, can that person make the decisions you want? If you have minor children, you can include language for who would serve as a guardian for your minor children if something were to happen to you. And then that way your family's not having to sort of second guess you. And I want to say anybody over the age of 18 needs these documents.
Wow.
We've had 25-year-olds who've had major accidents. We had a 50-year-old who, weeks after getting married, had a major stroke, had nothing in place. And what a heartache anyway for his wife to have to go through. And then on top of it, she had to file for guardianship. So getting these documents in place, doing it, if you have children going off to college, making sure they have a power of attorney and a healthcare surrogate. They don't need a will. Maybe they probably don't have any assets, but at least a healthcare surrogate and a power of attorney and a pre-need guardian should something happen because these things do happen.
I live in California. Here in California, the word is a will is like nothing without a trust, that you have to have a living trust to do anything, pass on assets without going to probate in California. You really have to have a living trust. Is that true in Florida, or is a will often good enough?
So Florida is different. Florida is one of only a handful of states that have what's called a ladybird deed. The legal term is an enhanced life estate deed. So it's like putting a beneficiary designation on real property. So you can have your home, have a ladybird deed, so beneficiaries inherit it. Without that, the house has to go through probate. You can, for bank accounts and IRAs and 401ks, have beneficiaries listed, pay on death accounts, have those beneficiaries listed. In Florida, we're fortunate where if a vehicle is paid off by statute, it does not have to go through probate. Your beneficiary can go down to the DMV, Department of Motor Vehicles, with the death certificate, a copy of the will, and get that vehicle transferred. So in Florida, what I advise people is if you're going to have a trust, you have what's called a pour over will, where if there is an asset for some reason that has to be probated, it's poured into the trust. In other words, it's distributed based upon the terms of the trust. If you don't have a trust, then you should be looking at a ladybird deed so that your property doesn't have to go through probate and it can be transferred upon death. So all your beneficiary does is file a death certificate with the clerk of court, which then the property appraiser, they keep up with any records that are being filed. And so they know that there's a new owner. So in Florida, everybody does not need to have a trust. So I always ask people when we're looking at is a trust appropriate or is a will appropriate? I don't want somebody paying for something they don't need and having a more complicated estate than they need. That's necessary. So we look at who are your beneficiaries and what are your assets. If you have beneficiaries that are minors, have special needs, have addictions, people you don't want to get money outright, then a trust is appropriate. If you have real property in other states, so let's say you have a homestead in Florida, and you have a cabin up in the mountains in Georgia or North Carolina. If you have a trust, you can put both of those properties, you can have them deeded into the trust, and neither would have to go through probate. Otherwise, I had one case where we had property in 4 different states. We had to do a probate here in Florida, and then we had to do what's called an ancillary administration in each state in which there was real property. So if they had all been in trust, there would have been no probate. Because there was no trust, there were 4 probates. So it's, again, meeting with an attorney and figuring out what it is that is appropriate for your case. It doesn't matter what your neighbor does, what your friends did, what other family members did. It all depends on what your particular situation is.
For listeners who don't know, if you've gotten this far, you probably do know what a trust is. But Wendy, can you give us a 2-sentence description of what a trust is?
Sure. So a trust is an estate planning tool where you can transfer assets into that trust. Most people are going to handle those assets themselves. They are what's called the trustee and will handle those until they no longer can, whether they're incapacitated or they have passed away. But then they'll have people set up who can take over immediately upon the death if it's just like a husband and wife, upon the death of both of them. And that person can then distribute those assets based on the terms of the trust.
The trust is like a box that you put the asset in, and it is controlled by a trustee. So it makes it much easier often to pass property to another person because it's not a change of ownership, it's a change of trustee.
There are some assets that you cannot put into a trust.
Ah,
If you have a 401k or an IRA, by federal law, those must be owned by an individual.
oh,
They cannot be put in a trust. So what we normally do is you either have a beneficiary where it's distributed outright to that beneficiary, or some people will name the trust as the beneficiary. But those are assets that can't. But the majority of assets, they can be. And the other thing that I see, speaking of assets in a trust, I have people who come in and they have these real fancy binders with all of these trust documents. And I ask them, well, what assets are in your trust? Well, I don't know. Did you ever retitle any bank accounts to your trust? No. Did you retitle your brokerage account to the trust? No. Did the attorney prepare a deed and transfer your real property into the trust? No. And so they spend all this money and have this fancy trust that's just paper. It does no good if it's not funded. And that's when you transfer property into the trust, it's funded. So when we do a trust signing, we provide the trustee with instructions. Okay, now this is what you need to do. Now, if there's real property, we can prepare the deed and we'll do that and prepare the deed and transfer the real property into the trust as long as it's Florida property.
Huh?
If it's another state, we tell them you have to contact an attorney in that state to transfer that asset into the trust. But that's one of the biggest issues I see with trusts.
We've been talking about things you need to do before you die, but when someone's passed away and you are the executor of their will, or what's called the personal representative assigned by the court, how does it go in Florida with probate and with trust administration? What's the typical scenario in Florida, and what special issues might people face there when they're dealing with a death?
With the probate, you must have an attorney unless it is a summary administration and you're the sole beneficiary. Then many times people don't get an attorney. Many times they end up coming to see us after they've tried to do it on their own.
Right.
It hasn't been very successful, so we have to fix a lot of things. But if you're doing a regular formal probate with a personal representative appointed, you must have an attorney. There's a lot of things that need to be done. And if you don't have an attorney and you're not in the legal field, you don't know. So first of all, when somebody you loved dies, you need to, ideally the attorney that that person used, because I know we hold on to a lot of original wills and you need the original will to probate it. So having conversations beforehand is always helpful, but it's helpful if you know who that person is. So you do need to have an attorney with a probate. With a trust administration, you are not required to have an attorney. However, I advise everybody to at least consult with an attorney. If you have everybody, they're on the same page, and they're working together, and there's not a lot of assets, and everybody's amenable, you can probably get away with not following the letter of the law because the only thing that needs to be filed with the court is a notice of trust. Everything else there's nothing else that's filed with the court unless there's litigation. But what trustees or successor trustees don't realize is you still have obligations. You need to keep the beneficiaries informed. You need to provide an inventory. If it's a trust that there's lots of different things going on, and the intent was to keep the money in trust and sort of dole out money over time, those beneficiaries need to be getting accountings. They need to get a notice of the trust and a copy of the trust. And what we find is the trustees have no idea what they're supposed to do and just try to do it on their own and end up not doing these things that they're supposed to do and get into trouble because then the beneficiaries are saying, well, we're not being told anything. I think they're stealing. They're not providing us with information. And then you have a trust action, which if somebody had hired an attorney and followed all the procedures, doesn't mean you're not going to get a trust action, but it's a lot less likely. If people know what's going on, there's not that suspicion. And many people forget to file a tax return. So there needs to be a tax return done on a trust. You need to get a separate tax ID. So there are a lot of little moving parts that if you have an attorney that's guiding you in that, you're much less likely to mess up and have somebody filing trust action against you. And as trustee, you can become personally liable for things if you don't do what you're supposed to do.
Well, wait, explain that. So my parent passes away. I have 3 siblings. I'm named as the trustee. I'm a busy guy. I let a couple months go by before I start filing paperwork, and I don't get an attorney. There's a bunch of money that's sitting in a bank. Maybe I use that money for the funeral. I use it to make house payments. 3 months from now, my siblings say, hey, what's happening with the money? And they have a right to do that. And maybe one of your siblings, you're not getting along that well, and they file an action in court to like, yeah, hey, you're not doing your job. And I could be personally liable, is what you're telling me.
Yes, and the court can remove you. Now, the personal liability comes in. Let's say there was a house in the trust, and the trust documents said to distribute that to a particular individual,
Uh-huh.
and you don't distribute that. And because you don't distribute it like you're supposed to, you're paying insurance and taxes and mortgage. And there's a hurricane here in Florida and the roof blows off and you're having to replace the roof. All of that money should not have come out of the trust. That property should have been distributed a long time ago. So then the other beneficiaries are saying, hey, you took what should have been our money and you used it to pay for this house that goes to somebody else. You owe us this money. So there could be some personal liability.
Not the estate, but you personally owe us this money.
Yes.
Wow.
Now, of course,
Wow.
the court would have to determine that you didn't do what you were supposed to do, but most of the time these things settle and they don't go to court. The families are able to, but a lot of times lots of money is spent unnecessarily because somebody didn't right from the get-go see an attorney and say, "What is it that I need to do? Somebody has died, I'm the trustee. What am I supposed to do?"
So probate is the process of going to court to get all this stuff settled, and you present the will to a judge. And how long does that take in Florida? And you said that it's required to have an attorney.
So it depends on the type of probate, but a formal probate where you have a personal representative appointed, that does require an attorney. We say that the statutes allow for up to a year to do a probate, but there are times that we need more than a year. One of the biggest reasons we're asking for more than a year is because we filed a tax return and we're waiting for a refund. So sometimes that can take months. But also, if there's multiple properties, if somebody had a business. Yeah, there's some estates that are fairly easy. You have a lot of cash assets. It's easy to distribute. We can get it done fairly quickly. But there are others that are much more complicated. And then, of course, when you get into litigation and people are fighting over things, not only does it cost more money, but it takes more time. So the importance for the person who's appointed, don't sit on things. Don't wait 6 months to go see an attorney if there's a probate, because there could be assets out there that you're supposed to be protecting. We had one where it took a long time. This was a trust action, took a long time for the trustee to do what she was supposed to do. We ended up filing a trust action. I represented one of the beneficiaries. But meanwhile, we had had a hurricane in Florida, and the house had an opening in the roof. Water was getting in, months and months of this happening. I mean, the house is in such disrepair, it just lost a lot of value because of mold growing in there, and then the contents of the house being destroyed. So, immediately doing what you need to do to secure assets, make sure they're safe. If it's a homestead, make sure it's locked, it's protected. If there's a hurricane, checking on it, making sure that there's no gaping hole in the roof. So it's a lot of responsibility being a trustee or being a personal representative of an estate.
If I'm named the successor trustee, do I have to take the job?
No, you do not. You can assign something saying, in essence, that you refuse to serve. And I always recommend for clients that they have a couple backups
Yeah.
so that if the first person is unwilling or unable, maybe that person's sick, maybe that person had COVID, maybe the person's deceased. So having some other people in line is really, and I say that with all the documents we prepare. You want to make sure you have some people named in the event the first choice doesn't work out for whatever reason.
If my parent retires, like they live in Indiana and they retire to Florida and they're there for 3 months and they pass away, is it all Florida law? I'm gonna have to go to Florida and I'm gonna have to do all this in Florida?
Yes,
Okay.
they're a resident of Florida,
Keep that in mind.
and that happens quite a bit.
I bet, right?
Yeah, that happens quite a bit.
It must happen all the time.
It does, it does. I've said this, but I'll say it again, the importance of making sure if you move down here, have your documents reviewed.
Yeah.
If you don't have documents, get some, and don't just go online and get this non-state specific language that isn't applicable to Florida. For most attorneys are not charging an enormous amount of money for a 1 hour consultation. And if it saves your estate thousands and thousands of dollars and makes sure that those individuals you want to get things and you're protected, your assets are protected, you're protected, it's worth the money spending.
A big message of this is, hey, you're moving to Florida. You really don't know what's going to happen. You really need an in-state attorney to look at your will and trust and get things straightened out. You don't know what a homestead is in Florida. You don't know how that works.
Right.
And if you're already in Florida, make sure you hire somebody to help you get your act together.
Right.
And that's not going to be an online robot, ladies and gentlemen.
And update it. Update it.
Update it.
Circumstances change. Beneficiaries pass away. Personal representatives that you wanted pass away. So keeping them current and looking at them. Ideally, you look at it once a year just to make sure. And then some things like a healthcare surrogate power of attorney, we recommend every 10 years you get a new one because they're considered stale. Financial institutions might not accept an old one.
Wow, Wendy, this has really been incredible, just laying out all this stuff. And as a resident of Florida, it's been especially meaningful to me. I know we're running short on time here. So, Marc, as we're wrapping things up, do you have any final thoughts?
Well, first of all, thank you so much for all your time today. It was super informative, a little scary, as always, I think, when people talk about these issues. They're such bigger issues than people realize they are, I think, all the time. And I think that's an important part of this show, is just getting across to people how vital it is to think these things through with an expert attorney. How can our listeners reach out to you for more information or seek your advice?
Well, we do have offices in Ormond Beach, Palm Coast, and Daytona Beach, and soon going to DeLand. And so we can look online, maralawpa.com. Call us. Phone number is 386-672-8081. We're always happy to hear from you. Even if there are some organizations that you can't afford an attorney, contact the Florida Bar. There are attorneys who do some pro bono work. Of course, you'd have to qualify financially. We do a lot of work with community legal services. People say, I don't have anything. Well, even if you don't have much of anything, you still have your person that you want to protect. So I would definitely at least get a power of attorney healthcare surrogate.
Thank you so much, ladies and gentlemen. That was Wendy Mara of Mara Law in Florida. Give her office a call.
Yeah, thanks, Marc. And thank you, Wendy, for being here today. It was a delight listening in. And it's a lot to think about as someone who lives just up the road from you in Gainesville. Lots of really good information there. And again, please check out Wendy's website. That's maralawpa.com. Phone number 386-202-2712. And thank you for making it to an end of another episode of Essential Estate Experts. We hope you enjoyed the show. If you don't mind liking, sharing, following us on YouTube, and if this video or audio presentation meant something to you, be sure to share it with a friend or family member that can benefit from the information. That'll mean a lot to them and it'll mean a lot to us, and it helps the show grow. As always, we want to thank you for joining us today. Until next time, we'll see you soon. Take care.
Thanks for listening to Essential Estate Experts, presented by Screenfire Media. Please remember to like, subscribe, ring the bell on YouTube, and rate us 5 stars on your favorite podcast app. It really helps. For more information, please visit screenfiremedia.com. Essential Estate Experts is copyright 2023 Screenfire Media, all rights reserved.